right now, the Supreme Court is getting another case in its shadow docket. According to Ian Millhiser over at Vox, whose opinion on these things I trust in terms of his assessment of the Supreme Court, it could be one of the most consequential cases involving trans people that we have seen in ages. And of course, I can't find the sheet.
It's West Virginia versus BPJ. BPJ is are the initials of a 6th grade student who... I
got it right here. Okay. And BPJ. And BPJ is and essentially what it basically is the case itself was a 6th grade student when she filed the lawsuit. She hoped to join the girls' cross country and track teams at her school. But because she's transgender, she was not allowed to under West Virginia law, which provides that school athletes must play for the team that corresponds with their, quote, biological sex. She sued to challenge this law. The case has bounced around since 2021. In our legal system, the fact that the law is discriminatory is not enough for BPJ to prevail. Government can discriminate all the time, and it does. He uses the example like the government discriminates against people under the age of 65 in terms of like who's eligible for Medicare. Right. Just as an example. The government discriminates as to who can get a driver's license or who can vote or who can drink legally. In addition to benefits, right? Like we're going to discriminate against you because you make too much money. You can't get SNAP.
Right. But there are certain categories that are given a high level of scrutiny about discrimination, and what that's sex and race, right? Right.
And the Supreme Court determined that there are groups that have experienced a history of purposeful unequal treatment, which, quote, frequently bears no relation to ability to perform or contribute to society, quote, should enjoy enhanced protections against discrimination. Like you say, this is called heightened scrutiny. In other words, there better be a very good reason to do this, like an exceptional reason. And in fact, you can also have different levels of the reason in which the government would discriminate. And this concept is embedded in the law in terms of things like takings. If you're going to, if the government is going to take somebody's property and pay them off, there has to be a high threshold. Or if we determine that something is, discriminatory in terms of race and this and that, there's different thresholds in certain situations as to who the discriminator is and whatnot. There's strict form of scrutiny. There is intermediate form. That run along this scale of heightened scrutiny. When they are heightened in this way, the burden of proof shifts from the person who's trying to prove that the discrimination is wrong to the discriminator, in this case, the government. If you are in a category that exists this way, who has to prove whether there is discrimination or there is not discrimination changes. The state can potentially rebut this presumption. In other words, when they arrive at court, a presumption that any governmental discrimination against them is unconstitutional. Like clearly, this kid is being discriminated against. But the question is it constitutional for the government to do this? This case could very well determine whether transgender kids and adults are categorized as needing a heightened level of scrutiny if you're going to discriminate against them.
Which would be very broad legal protections for transgender people in this country.
Or an absence.
Well, yeah. And then that's where we're in trouble with this extremist right-wing Supreme Court that seems posed to take this also on the shadow docket, meaning they could just essentially issue a ruling saying, we agree with West Virginia, and we're not really providing any other explanation.
Right. Which means there's an absence of strict scrutiny. And that's basically what we're dealing with. Was this guy, is now number 6, is this the guy?
This is the judge, Kyle Duncan.
Now, somewhat related, this judge who found that in West Virginia versus BPJ, that this discrimination is okay, and sent it up to the Supreme Court, essentially, or the plaintiffs did. He went to go give a talk at Stanford University. Now, I will say this. It was, a Federalist Society event. It's nice to see the Stanford University students take issue with this. Is Wu still working there?
No, yeah, that's a good question. Oh.
The guy who basically said the president has the right to torture. He might be a good candidate also to be protested. Nevertheless, here is what happened when the Judge Kyle Duncan, Fifth Circuit Court of Appeals, clip number 1, he doesn't like the fact, and remember, they allowed him to speak, but he doesn't like the fact that he's getting questioned. So here he is, he has the opportunity for free speech, but he's still really offended.
I'm going to triple down on it, and I'm going to quadruple down on it because you are willfully misunderstanding.
No, I know what it might be your question.
Great. So in other words, it's a loaded question.
No, it assumes a fact, not an evidence.
Yes, thank you.
Which I didn't do. I didn't assume any facts. I asked you, do you think that considering the ethical implications of your decisions is outside the scope of your work?
Do you mean, I don't understand the question. Do you mean the rules of judicial ethics?
I mean, when the
rules of judicial ethics?
You know as well as I do that the courts weigh different interests all the time, that they all the time consider like fairness among a range.
Now pause it. I want to just say something here from my short time at law school. What she's asking is actually a question that the discipline of critical legal studies, not critical race studies, critical legal studies, and in fact examines, but also even the tradition goes much further back with Judge Brandeis. When Judge Brandeis was a lawyer, one of the things he argued in front of the Supreme Court was child labor laws. And the argument that he made was like, it is not in society's ethical interests to have children working, or I should say, it's not in society's interest, both because you don't want children working in factories, you don't want people working maybe 40 hours a week or whatnot. It's also unethical. Like, it's not the sign of an evolved society. And she's asking him a very simple question. Do you, as a judge, ever consider the ethical, one could probably say moral, implications of what you rule? That's it. I mean,
well, that makes him very uncomfortable because he can't answer that question. I mean, we'll get to it, but there's a whole group of legal thinkers and judges who want to act as if they are handing down a proclamation that is just by the letter of the law and absent of any kind of subtlety or nuance or subjectivity from the society that we live in. And oftentimes, and almost actually I would say 100% of the time, that's the way conservatives portray themselves and conservative judges brand themselves to the public because they don't want to deal with the moral implications of their ruling. And when you look even just an inch deeper into what they're saying, they're making determinations about a moral society on their own. It's just that they don't like to couch their decisions in those terms.
It was John Yoo, and he is at Berkeley, so I apologize.
Well, actually, Trump appointed you to a 4-year term on the National Board for Education Sciences, which advises the Department of Education on scientific research and investment.
Oh, nice. So. Yeah, I wonder if he's doing a lot of biological research. All right, anyways,
science.
Here is, let's continue with this.
I'm going to triple down on it, and I'm going to quadruple down on it because you are willfully misunderstanding.
No, I know what it might be your that considering the ethical implications of your decisions is outside the scope of your work?
Do you mean, I don't understand the question. Do you mean the rules of judicial ethics?
I mean, when
The rules of judicial ethics?
you know as well as I do that the courts weigh different interests all the time, that they all the time consider like fairness among a range of different required considerations. How does that factor into your ethical considerations as a judge?
So let me see if I can unpack this. Judges are ruled by rules of ethics. They're codes of ethics. Do we consider them? Oh, you bet we do.
No, I don't mean that.
You don't mean that. You mean, do I sit back and sort of say, well, what is fair? What is fair? What do I think is fair? The answer is judges aren't supposed to engage in some sort of cosmic fairness balancing because we have elected officials to do such things. We have elected officials.
You know, I mean, aside from the drippy condescending tone, and listen, I think if anybody knows the drippy condescending tone, I think I should.
Yeah.
But I don't know that I would talk to students in a law school class like that because I didn't like, you could say like, this is the way you answer that question. I got to be honest with you. I perceive making an assessment as to whether something's fair. Now, first he played this game like, I don't know what you're talking about.
Right. Is it the legal ethical code? No, we're not talking about what will get you disbarred or not.
You're asking about outcomes as to the implications of my rulings. And now, the most honest response would be like, look, I'm human. And of course, I perceive outcomes on some measure. But one thing that we endeavor to do as a judge is to ignore those outcomes and determine it based upon the law because the legislature does this.
I restrain myself judicially. I am not a judicial activist. I mean, that would be bullshit, but it would be fine to answer it respectfully in that way.
And of course on the Supreme Court, they do that all the time.
Yeah, I was going to say, can we get rid of the Supreme Court then?
They do that all the time. And judges, of course, do that. Now, why do we know that judges, of course, do that? Because you give me a case, a controversial case, tell me who appointed that judge, and I will tell you what the outcome is. We go through that every day. About, 6-7 years ago, I said to Brendan, do not give me a court case without telling me who the judge was that decided, who appointed that judge. And I have yet, maybe there was one case out of the literally hundreds that we've probably reported on that I've read about where I was like, George Herbert Walker appointee decided this way. I'm surprised by that.
Yeah. I mean, and we talk about this all the time too, how judges view themselves as philosopher kings and priests. They really want everybody to subscribe to a fiction that they're making these determinations based on some philosophical moral code that they've decided at the start of their legal careers what they're going to pursue, as opposed to the changing tides that cause them to have reactions to political moments because they exist in the society. Like, judges exist in the society. It's ridiculous that they try to isolate themselves from that in terms of public discourse. But yeah, that is, some of the gatekeeping that's involved in the legal profession. And these are Stanford University kids, right? This is the closest that they get to being called out from the plebeians on their shit.
Now, apparently, let's play some of the clip. Do we have part of the clip where they're shaming him? Someone's saying that we're not playing the shaming part. Do we have that first part of the clip?
I'm looking forward to the shaming part, actually.
I got to be honest with you folks. I am not one of those people who have a problem with shaming people publicly. In fact, particularly when you have unelected people, but also elected people, frankly. I don't think that people should be violent. And I don't doubt that students can be excited and harassing and whatnot. But I do think if you sit on a court where your decision can impact millions of lives, like if you are a circuit court of appeals judge, it will. what is it, like 5 or 6 states, 4 states, 3 big states. I don't know. Fifth Circuit's also lunacy. I think it's okay to sort of like protest in front of these people. And
actually, you should, because they, as I just said, they aren't in front of an audience like this that's going to call them out regularly. This is important.
I mean, the clip we just watched was, I think, a ideal environment. Like, I think students should have that relationship with the people that come and speak to them. So
apparently,
really
like
great.
the first, like, what was it, 10 minutes, 15 minutes of the thing? Let's play this clip. Was, really ugly. And just be careful, folks, if you're at work or if you're with small children. You may not want to see this. Let's play this clip.
Not persuaded? It makes sense. Super. Great. Good. Next question.
I did read it just before this, and I'm confused how that squares with what you said about being respectful of people when you're talking about, like,
Yeah, I thought the meeting was perfectly respectful. I gave reasons. That's what judges do. I gave reasons.
It's a slippery slope argument about, like, using a bunch of different pronouns and what could happen if you chose a specific
Yeah, we're
word.
talking about you read the opinion. Next question.
But you didn't answer my question, which is, like, why did you think that you couldn't be respectful to one litigant without somehow causing downstream
For
effects?
the reasons that I gave in the opinion. Thanks.
How about you give it to us?
Next question. How about you ask me a question?
We did.
Yeah, okay. Can you give them to us as the next question? All right. Well, look, thanks to the Federalist Society for inviting me. As far as the rest of you people, yeah, whatever.
All right, that's at the end, right? I want to see the beginning part. Yeah, the beginning when there was when they were harassing him, because that seemed really, really ugly. Oh, here it is. I just sent it there. Someone asked him if he is 96.
Oh, I saw. Is this the ageism thing where they're like the people like laughed because he said he was old or something?
Well,
like that?
no, he was asked if he was. He asked them first. Watch here. Let's play this one.
Are you 14 years old?
All right, start it over again so we can hear what he says, because that predates what that precedes. Okay, go ahead.
Are you 14 years old? Are you 14 years old?
Are you 96?
No.
Me, your head looks like that.
What? No, I'm sorry. I was distracted by the stupid, infantile 14-year-old sign. Yeah, you are.
Okay. Was this the part that I missed that was really offensive? He said, "Are you 14?" And what was the what does that sign
The
say?
sign
Can
said
we-
Fed sucks.
Oh, the Federalist Society sucks.
It does. That's a good sign.
Yeah, agreed.
What?
I mean, honestly, there are so many different professions of people that could have gone into that situation and handled it and said, like, these are kids, maybe I'm a conservative, but they're emotional and I'll handle it myself. But like that, judges like that are never, ever, ever held to account. They're only treated like, these beautiful stewards of our democracy. And that's refreshing. More of that, in fact, especially if he's getting paid to speak there. Are they not
I don't know if
entitled?
he's getting paid to speak there. Maybe he is, maybe he isn't.
I don't care either way.
But I just want to be clear too about, like, before the video came out, guys like Ed Whelan, if you'll remember him, that guy who the legal scholar who was like, during the Kavanaugh hearings, he was like, I found on Zillow that this might be the guy who harassed Dr. Ford. He was like, the DEI person who brought the people to the class should be fired. Like, they were so disrespectful. And like, you watch the video and like, he's castigating these.
All right, play this. Let's see even a little more. I mean, because Ryan Grimm is somebody was keeps tweeting us. Can you talk to Ryan Grimm about this? And he says, I see most people. Okay, he says like blatant ageism.
Yeah, I mean, to say, are you 96, I guess that's ageist, but is that really like something to give a shit about?
It's just
who
responding
cares?
to the 14. I mean, these guys maybe are not like, wordsmiths in the context of their protest. But
What, because they're 19 and 20?
yeah, I mean, I think like, okay, yes. If somebody says to you, are you 14? You say, are you 14? Because that's the way what a 14-year-old would say.
I mean, we want to play it?
I am an associate dean, and I would love to answer your question. Can I? Yeah, and to this room, because you're asking to the room as well. Is that okay?
Associate Dean, what do you want to say?
She doesn't need your cousin out.
Is that okay? Because you are also talking to the room.
You asked for an administrator. She is an administrator.
You just asked for an administrator in here.
You want an echo chamber, or you want someone to
Oh, good. I mean, you know what? Like, honestly, like, the only thing I'm going to get out of this is that, yes, you know what? Maybe I'll take I'll take that other kid who responded with 14, are you 96, to quip school, and we can come up with a better quip response in that moment to this judge. But I got no problem with this. I got no problem with this because, and I'll tell you why. Aside from this moment, and I know that, like, I know that, you know, the way that this is being, you know, at least, you know, Ryan's complaint here is that, like, are you really, like, gaining any power here? I honestly think that the most important project that can be done in terms of judges in the judiciary at this point is to show that this institution is corrupted and problematic. And I think this does do that. I think it sends a message to other people.
And respectful silence sends its own message.
Mm-hmm. And I will say that, like, again, the biggest problem I've had with the center to the left in terms of the judiciary is they don't pay enough attention to it. And if people are going and protesting, good. That means that they're paying attention to it. I'm willing to entertain the notion that, you know, maybe we should be doing a protest class, and we could do like a learning annex class on the best quips to have when you're, you know, the best legal quips for the judge. But yeah, I think, would I have said 96? No. So what? I would have said, like, I don't know, are you a butthead?
Why are we even
like
wasting time tone policing the Stanford Law students?
crazy,
I mean,
right?
I'm being somewhat facetious.
No, I understand,
here.
but I mean, I love Ryan, but what are we doing here?
Yeah.
I mean, the idea that that's the emphasis as opposed to this guy's a complete right-wing freak who had to deal with a modicum of incivility because of the consequences of his decisions that are going to affect millions of people.
The
Give me a break.
associations that got him into that room.
But the first clip, I will say, I also feel like, sure, was it a contentious exchange?
Oh, that exchange
but
is
he's-
absolutely fine.
But he's yelling at her, and she's responding substantively. I think that's like.
Well, he doesn't quite have judge. He doesn't have quite to have judge judicial
department.
temperament.
Yeah, right.
Yes.
The judicial, yeah. What about whatever happened to judicial?
Sounds like he's
I will-
getting
I
a
will say
little
this.
emotional.
I will say this, and then we can wrap it up. But Illuminati Kids has a good pitch. I'm going to pitch that the student should have said, "No, I'm 69." Respectful to the elderly with a double meaning. Yeah, that's what I'm talking about.
Good edit.
Yeah, God bless you, kids. Good job.
Yeah, 69 would have been better than 96. Good for those kids, honestly. He should know. One of these things that these judges don't know, more often than not, is that there are other people out there who disagree with them.